What are the different types of powers of attorney in Ohio? Stay tuned to find out. Hey guys, Elliott Feldman here, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. If you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. Okay, let's talk about the different types of powers of attorney in Ohio when it comes to your estate plan. So first, let me go through what a power of attorney is. So a power of attorney is something that just about everybody does when they're getting their legal affairs in order and building out a comprehensive estate plan. You see, it's a legal document where you give someone else the authority to do things on your behalf when you are unable to do so. And typically, we're talking about when you're unable to do so, you're mentally incapacitated, you're in a coma, you're appointing someone to be making medical decisions on your behalf and making financial decisions on your behalf. Now, there are many issues that arise that you need to consider when you're forming your powers of attorney, but in this video, we're just gonna build on our foundational knowledge and just touch on the different types of powers of attorney that you can create. Number one, the general power of attorney. The general power of attorney is very broad in its scope because you, as the principal, right, are giving the person that you name to be your general power of attorney or the agent all of the powers and authority that you currently have right now, meaning virtually any transaction that you can do for yourself, you are giving that power in your agent or power of attorney to be able to do so on your behalf. As an example, you give someone a general power of attorney, they can go access any financial account that you own and take money in, put money out, pay for things out of that financial account. So it's very, very broad sweeping authority, which of course is, generally a good thing. If you're in a coma and you need someone to pay the bills out of your bank accounts, you want someone to have that kind of power. Number two, the limited power of attorney. Now, unlike the general power of attorney, the limited power of attorney only gives your agent the power to act on your behalf for a limited purpose. So in my prior example, instead of giving your power of attorney general power to get in and out of any financial account you own, you could explicitly state that they only have the ability to access your checking account to make transactions on your behalf, but not your savings account or your mutual fund. Another example, a client might say to me, Elliott, I'm going out of town for the next 3 weeks. My house is closing next week and I'm not going to be around to be there at the closing. So I want to appoint my friend Chris to have the power of attorney to sign for me at the closing, but I only want Chris to be able to sign for me for that closing of the real estate transaction. I don't want him to be able to do anything else for me with that power of attorney. That's where a limited power of attorney would really come into place. Number three, the durable power of attorney. So what do you mean by durable, Elliott? Well, a durable power of attorney means it remains effective even after you become incapacitated, meaning if you end up in a coma in a hospital and you name someone to be your agent and a durable power of attorney, then your agent will still have the power to transact on your behalf while you're in a coma. And quite frankly, that's the main reason why people create powers of attorney, so that they can have someone that they trust be able to take care of things for themselves when they are unable to do so because they're mentally incapacitated, right? Number four, the springing durable power of attorney. Okay, this comes down to the actual timing of when your agent gets the power to act on your behalf. So typically when you name someone to be your durable power of attorney, especially if it's someone you really trust, like your parent, your brother, your sister, etc., you immediately give them the ability to act on your behalf. But if you didn't want them to immediately have that power, you could just write in your document that your durable power of attorney would not have the ability to act on your behalf until you become mentally incapacitated and unable to act for yourself. Moreover, the durable power of attorney would only spring to your agent when you end up in a coma or succumb to dementia. So as an example, a client would come to me and say, hey, Elliott, I want my son to have power of attorney for me, but while I'm still in a good state of mind, I don't want my son to have power of attorney. Like, I'm a little worried that he might get influenced by his wife to do something stupid and drain my bank account, so I want my power of attorney only to become effective if and when I ever become incapacitated. But while I'm healthy, Elliott, nobody's gonna have power of attorney to get access to any of my stuff. In that case, you'd create a springing durable power of attorney with the son named as the agent. Now, it's probably worth mentioning at this point that most people don't go this route by creating a springing power of attorney, because they really prefer it to immediately take effect. You see, the big issue with springing powers of attorney is defining the criteria to determine if you've become mentally incapacitated. You see, mental incapacity is sometimes a little tricky to define, and it can get a little tough to get doctors to sign affidavits stating you're mentally incapacitated based on the criteria you defined in the document. As you can imagine, by adding this hoop to jump through, this can seriously delay the agent you named to be your springing durable power of attorney from actually getting the power to act on your behalf at a time when decisions typically need to be made fast. Like our recent example, the son has a springing power of attorney, the dad ends up in a freak car accident. Now the dad will need 2 doctors to sign affidavits saying that he's mentally incapacitated based on your definition before the son can access the dad's bank account to pay the mortgage on the dad's rental properties, which happen to be due that day. Maybe he won't be able to, make those payments on time because he had to call the attorney to get the affidavits, then get 2 separate doctors assigned, then take those signatures to the bank and hope the bank accepts the affidavits to allow him to actually access the accounts as the power of attorney, right? A lot of things would have to line up and it would just take a long time. It wouldn't be fast, which again could cause some issues. All right, so in summary, there are 4 different types of powers of attorney in Ohio when it comes to your estate plan. There's the general power of attorney, who you give broad authority to make transactions on your behalf. There's the limited power of attorney, who you give the power to only do specific things on your behalf. There's the durable power of attorney, which is the standard power of attorney most people go with since it goes into effect immediately and remains in effect after you become mentally incapacitated. And finally, there is the springing power of attorney, which doesn't go into effect immediately, but only goes into effect after it has been determined that you have become mentally incapacitated. Ultimately, it's important to get a power of attorney because if you didn't have a power of attorney in place and then you later become incapacitated, your family would need to go to court and have the court determine that you were mentally incapacitated and then get the court to approve of someone to act as your guardian or custodian in order to make decisions on your behalf, and who that person becomes is out of your control, and the process to get that person appointed and in place is much more costly and cumbersome than just creating a power of attorney in the first place. Hey, thanks so much for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then please hit the like button. And if you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. And if you ever have any questions about this topic or need to talk about your estate planning needs, you can set up a time to talk with me over the phone for free by going to myestatemeeting.com. That's myestatemeeting.com. Again, this is Elliott Feldman, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. Take care.